Minnesota real estate closing costs questions. Question 1. A seller says the basement is perfectly dry despite knowing of repeated water intrusion. Why is that more than ordinary puffing for Quinn and Woodbury involving a mixed-use property priced at $453,500? Option A. It is a factual misrepresentation about a material property condition. Option B. It is always protected opinion regardless of knowledge. Option C. It is allowed if the buyer gets a loan. Option D. It becomes legal if stated verbally instead of in writing. The correct answer is option A. It is a factual misrepresentation about a material property condition. A specific false statement about a known material condition can be misrepresentation. Puffing is general opinion, not a false factual claim about water problems. Financing approval or verbal delivery does not make a known material misstatement acceptable. Question 2. A deed expressly creates survivorship between co-owners of a condominium unit. Which ownership feature is being emphasized for Rowan and Stillwater involving a condominium unit priced at $399,500? Option A. No right to possess the property. Option B. Right of survivorship in joint tenancy. Option C. A tenant's trade fixture right. Option D. A mortgagee's foreclosure priority. The correct answer is option B. Right of survivorship in joint tenancy. Joint tenancy is associated with right of survivorship when properly created. Co-owners generally have possession rights, and trade fixtures concern tenants rather than co-owner succession. Mortgage priority is a lien issue, not survivorship ownership. Question 3. A property use existed legally before a zoning change and may continue despite the new rule. What is it called for Schuyler in Northfield involving a rental house priced at $388,000? Option A. Blockbusting. Option B. Estoppel certificate. Option C. Legal non-conforming use. Option D. Defeasible fee only. The correct answer is option C. Legal non-conforming use. A legal non-conforming use lawfully existed before a zoning change and is often allowed to continue under limits. Blockbusting is a fair housing violation. Estoppel certificates relate to leases or representations, and defeasible fee is an ownership estate. The timing before the zoning change is key. Question 4. Under Minnesota law, which statute is the primary source for real estate broker and salesperson regulation for Riley and Bloomington involving a farm parcel priced at $404,000? Option A. Minnesota Statutes Chapter 287 only. Option B. The Federal Internal Revenue Code only. Option C. A local MLS policy manual only. Option D. Minnesota Statutes Chapter 82. The correct answer is option D. Minnesota Statutes Chapter 82. Chapter 82 governs real estate brokers and salespersons in Minnesota. Chapter 287 covers deed tax and mortgage registry tax topics, and federal tax law or MLS policies do not replace state licensing law. Exam questions often test which authority controls licensing conduct. Question 5. A buyer representation agreement in Eden Prairie is best described as what type of document? Option A. A written contract that creates agency representation for the buyer. Option B. A deed transferring title to the buyer. Option C. A loan commitment from the lender. Option D. A property tax statement from the county. The correct answer is option A. A written contract that creates agency representation for the buyer. A buyer representation agreement is the written contract that creates buyer agency. It does not transfer title, approve financing, or state county taxes. Representation contracts define the broker-client relationship and compensation terms. Question 6. An easement benefits a neighboring parcel by allowing driveway access across Rowan Okafor's land. What type of easement is most likely? Option A. Personal license only. Option B. Easement appurtenant. Option C. Trade fixture. Option D. A mechanic's lien. The correct answer is option B. Easement appurtenant. An easement appurtenant benefits another parcel and usually runs with the land. A personal license is revocable permission, a trade fixture is tenant property, and a mechanic's lien secures payment for improvements. The presence of a benefited parcel points to an appurtenant easement. Question 7. If one broker represents both Jordan Miller and Blair Patel in a residential transaction, what must occur before the broker acts as a dual agent? Option A. Only the seller must consent because the seller listed the property. Option B. The broker may proceed without consent if the commission is reduced. Option C. All parties must give informed consent to the dual agency relationship. Option D. Consent is unnecessary if two different salespersons are involved. The correct answer is option C. All parties must give informed consent to the dual agency relationship. Dual agency requires informed consent from the parties because the broker owes duties to both sides and cannot advocate exclusively for either one. A lower commission does not remove the conflict, and two salespersons licensed to the same broker can still create dual agency. Seller-only consent is not enough. Question 8. A buyer transfers contract rights to another buyer but remains liable unless released. What is this called for Quinn and Woodbury involving a mixed-use property priced at $313,500? Option A. Novation with automatic release. Option B. This cheat. Option C. Ad valorem taxation. Option D. Assignment. The correct answer is option D. Assignment. Assignment transfers contractual rights to another party, but the assignor can remain liable unless a release or novation occurs. Cheat and ad valorem taxation are unrelated. The distinction between assignment and novation is commonly tested. Question 9. A social media ad for a rental house in Northfield uses a team name. What must the advertisement clearly and conspicuously display for Skylar in Northfield involving a rental house priced at $329,500? Option A. The real estate brokerage name. Option B. Only the salesperson's nickname. Option C. Only the property street address. Option D. Only the team logo without the brokerage. The correct answer is option A. The real estate brokerage name. Minnesota advertising rules require the brokerage name to be clearly and conspicuously displayed. A team name may be used only with broker authorization and the brokerage name still must appear. Nicknames, street addresses, and logos do not replace the required brokerage identification. Question 10. Under Chapter 82 standards, what must a broker do to properly supervise salespersons at a Woodbury office for Quinn and Woodbury involving a single-family home priced at $263,000? Option A. Let each salesperson approve their own contracts without broker review. Option B. Monitor brokerage activities, review transaction documents, and review trust account books and records. Option C. Delegate all trust records to buyers and sellers. Option D. Supervise only advertising and ignore purchase agreements. The correct answer is option B. Monitor brokerage activities, review transaction documents, and review trust account books and records. Broker supervision includes ongoing monitoring of salespersons, transaction documents, and trust account records. Salespersons do not self-supervise, and clients are not responsible for brokerage trust accounting. Limiting supervision to advertising would miss major broker responsibilities. Question 11. If annual property taxes of $5,850 are prorated to the seller for 230 days on a 365-day basis, approximately what amount is charged to the seller? Option A. $16,825. Option B. $3,533. Option C. $3,686. Option D. $1,276. The correct answer is option C. $3,686. Tax proration divides the annual tax by 365 and multiplies by the number of seller days. Commission, discount points, and monthly interest are unrelated calculations. Proration allocates an annual expense fairly between buyer and seller at closing. Question 12. A buyer pays 3% in discount points on a $201,875 loan. Approximately how much are the points? Option A. $1,136. Option B, $35,625. Option C, $14,844. Option D, $6,056. The correct answer is option D, $6,056. One discount point equals 1% of the loan amount, so the points are calculated by multiplying the loan amount by the point percentage. Monthly interest, down payment, and commission are calculated from different formulas. The point charge is a loan cost calculation, not a sales commission or equity contribution. Question 13. A rental property produces $54,500 in net operating income and investors require a 6.5% capitalization rate. What value is indicated by the income approach? Option A, $838,462. Option B, $282,750. Option C, $334,475. Option D, $12,750. The correct answer is option A, $838,462. The income approach using direct capitalization divides net operating income by the capitalization rate. Gross rent multiplier, loan amount, and frontage calculations use different inputs. The cap rate converts expected net income into an indicated value. Question 14. At the end of a Minnesota tenancy, what must a landlord generally do with the tenant's security deposit after receiving a forwarding address for Cameron in Brainerd involving a small retail building priced at $210,000? Option A, keep the entire deposit automatically as a cleaning fee. Option B, return the deposit plus interest or provide a written explanation of lawful deductions within the required time. Option C, apply the deposit to the broker's commission. Option D, record the deposit with the county as a deed restriction. The correct answer is option B. Return the deposit plus interest or provide a written explanation of lawful deductions within the required time. Minnesota law requires the landlord to return the deposit with interest or provide a written explanation for lawful deductions within the required period. Automatic forfeiture, commission payment, and county deed restrictions do not match the security deposit rules. Security deposits remain tenant funds unless a lawful deduction applies. Question 15. Why should a purchase agreement for a townhome in Eagan be in writing and signed by the party to be charged? Option A. All oral contracts are criminal offenses. Option B. Only lenders may sign real estate contracts. Option C. The statute of frauds requires most real estate sale contracts to be in writing to be enforceable. Option D. A deed is unnecessary if the parties shake hands. The correct answer is option C. The statute of frauds requires most real estate sale contracts to be in writing to be enforceable. The statute of frauds generally requires contracts for the sale of real property to be in writing and signed by the party to be charged. Oral agreements may fail enforceability even if the parties intended a deal. Lender-only signatures and handshake transfers do not replace the required written contract and later conveyance documents. Question 16. An advertisement says a farm parcel is available only for adults with no children. What is the main fair housing concern for Jordan in Duluth involving a farm parcel priced at $352,000? Option A. The ad forgot to mention the roof age. Option B. The ad uses a list price instead of an appraised value. Option C. The ad includes the city name. Option D. The statement indicates a preference or limitation based on familial status. The correct answer is option D. The statement indicates a preference or limitation based on familial status. Advertising cannot indicate a discriminatory preference or limitation based on familial status except where a valid housing for older persons exemption applies. Roof age, list price, and city name are not the fair housing issue in the wording. The problem is discouraging families with children. Question 17. If an override clause appears in Taylor & Nguyen's listing agreement, what must the licensee provide within 72 hours after the listing expires for the clause to be effective? Option A. A protective list. Option B. A new deed. Option C. A county tax appeal. Option D. A mortgage payoff statement. The correct answer is option A. A protective list. An override clause is tied to a protective list supplied within the required time after expiration. A deed, tax appeal, or payoff statement does not preserve the broker's override rights. The protective list identifies prospects covered by the clause. Question 18. A Bemidji parcel contains 5 acres. How many square feet are in the parcel? Option A, $55,200. Option B, $217,800. Option C, $171,200. Option D, $4,473. The correct answer is option B, $217,800. 1 acre contains 43,560 square feet, so acreage is converted by multiplying acres by 43,560. Frontage value, loan amount, and tax amount are calculated from different data. Unit conversion is a common real estate math task. Question 19. 2 investors own a Bemidji duplex with unequal shares and no survivorship language. Which ownership form is most likely for Reese in Bemidji involving a vacant lot priced at $277,500? Option A, tenancy by the entirety. Option B, severalty. Option C, tenancy in common. Option D, life tenancy only. The correct answer is option C, tenancy in common. Tenancy in common allows unequal ownership shares and has no automatic right of survivorship. Severalty means one owner, and a life tenancy is measured by a life. Tenancy by the entirety is a special marital form not described by unequal investor shares. Question 20. What is the main purpose of an owner's title insurance policy for Quinn Anderson? Option A. To insure the roof against storm damage. Option B. To guarantee future market appreciation. Option C. To replace the need for a purchase agreement. Option D. To protect against covered title defects that existed before the policy date. The correct answer is option D. To protect against covered title defects that existed before the policy date. Owner's title insurance protects against covered past title defects, liens, or ownership issues discovered after closing. It is not property casualty insurance, an appreciation guarantee, or a substitute for the purchase contract. Title insurance focuses on ownership risk, not physical damage or investment performance. Question 21. Which deed gives Riley Nguyen the broadest set of title warranties from the grantor? Option A, general warranty deed. Option B, quitclaim deed. Option C, bargain and sale deed with no covenants. Option D, tax certificate only. The correct answer is option A, general warranty deed. A general warranty deed provides the strongest customary covenants of title from the grantor. A quitclaim deed conveys whatever interest the grantor has without warranties. A bargain and sale deed without covenants and a tax certificate provide less assurance than a general warranty deed. Question 22. A lender offers Cameron Davis a mortgage whose interest rate can change based on an index after an initial period. What type of loan is this? Option A, package mortgage only. Option B, adjustable rate mortgage. Option C, open-end listing. Option D, a graduated lease. The correct answer is option B, adjustable rate mortgage. An adjustable rate mortgage has an interest rate that may change according to an index and loan terms. A package mortgage includes personal property, an open-end listing is not a standard listing type, and a graduated lease changes rent over time. The index-based interest change identifies the loan type. Question 23. A facilitator working with Quinn in Mankato performs services without representing either side. Which fiduciary duty generally remains unless expanded by written agreement? Option A, loyalty to the seller only. Option B, obedience to the buyer's investment goals. Option C, confidentiality. Option D, advocacy for the party paying the commission. The correct answer is option C, confidentiality. A facilitator does not act in a fiduciary capacity as a buyer's broker, seller's broker, or dual agent, but confidentiality remains a duty unless the relationship is expanded by written agreement. Loyalty, obedience, and advocacy belong to agency representation, not ordinary facilitator status. Commission payment does not create fiduciary representation by itself. Question 24. A seller accepts an offer only after the buyer receives financing approval. What type of clause is most likely involved for Morgan and St. Cloud involving a duplex priced at $213,000? Option A, Habendum clause. Option B, subordination clause. Option C, acceleration clause only. Option D, a financing contingency. The correct answer is option D, financing contingency. A financing contingency makes performance depend on loan approval or financing terms. A habendum clause appears in deeds, subordination changes lien priority, and acceleration makes a debt due after default. The condition involves financing approval. Question 25. A loan payment schedule gradually reduces principal until the loan balance reaches zero. What financing term describes this for Quinn and Woodbury involving a single-family home priced at $276,500? Option A, amortization. Option B, accretion. Option C, subordination. Option D, this cheat. The correct answer is option A, amortization. Amortization is repayment of a debt through payments that reduce principal over time. Accretion is natural land buildup. Subordination changes lien priority, and escheat transfers property to the state when no heirs exist. The decreasing loan balance is the clue. Question 26. Recording a deed for a townhome in Carver County primarily gives what type of notice to the public? Option A, private notice only to the buyer's lender. Option B, constructive notice. Option C, a zoning variance. Option D, a guarantee of physical condition. The correct answer is option B, constructive notice. Recording places an instrument in the public records and gives constructive notice of the recorded interest. It does not create a zoning variance or guarantee the property's physical condition. The public records system protects priority and notice, not building quality. Question 27. A seller instructs the licensee not to disclose a known structural defect to buyers. Which principal controls for Kendall in St. Paul involving a rental house priced at $358,500? Option A. The licensee must obey every instruction from a client. Option B. The defect becomes confidential forever. Option C. The licensee cannot obey unlawful instructions that conflict with required disclosure duties. Option D. The buyer's broker alone must discover every defect. The correct answer is option C. The licensee cannot obey unlawful instructions that conflict with required disclosure duties. Obedience applies only to lawful instructions. A client cannot require a licensee to hide a material fact that law requires to be disclosed. The duty to disclose known material defects is not shifted entirely to the buyer's broker. Question 28. For Quinn Wilson's first real estate job in Eden Prairie, who submits the Minnesota salesperson license application after the applicant becomes associated with a broker? Option A. The applicant directly through a personal account only. Option B. The listing client from the applicant's first transaction. Option C. The county recorder in the county where the applicant lives. Option D. The licensed real estate broker with whom the applicant is associated. The correct answer is option D. The licensed real estate broker with whom the applicant is associated. A Minnesota salesperson must be associated with a licensed broker, and the broker submits the license application. The applicant alone does not file the salesperson application, clients have no filing role, and county recorders do not issue salesperson licenses. Broker sponsorship is central to salesperson licensure. Question 29. A sudden flood removes soil from a riverbank in Olmsted County. What term describes the sudden loss for Schuyler in Northfield involving a fourplex priced at $203,500? Option A, avulsion. Option B, accretion. Option C, assemblage. Option D, plottage. The correct answer is option A, avulsion. Avulsion is sudden loss or change of land by natural forces. Accretion is gradual buildup, assemblage combines parcels, and plottage is the value increase from assemblage. The word sudden distinguishes avulsion. Question 30. A buyer includes an inspection condition in a St. Cloud purchase agreement. What is the role of that contingency for Morgan and St. Cloud involving a duplex priced at $204,500? Option A. It automatically transfers title to the buyer. Option B. It makes the buyer's duty to perform depend on the stated inspection condition being satisfied or waived. Option C. It eliminates the need for earnest money accounting. Option D. It makes the broker a home inspector. The correct answer is option B. It makes the buyer's duty to perform depend on the stated inspection condition being satisfied or waived. A contingency is a condition that must be satisfied, waived, or otherwise resolved for the contract obligations to proceed as written. It does not transfer title or remove trust accounting duties. The broker does not become the inspector merely because the contract contains an inspection contingency. Question 31. Why is the Minnesota agency disclosure form given to Harper Miller not enough by itself to create representation? Option A. It automatically creates dual agency for every transaction. Option B. It replaces all purchase agreement requirements. Option C. It is a disclosure only, and representation requires a written listing contract or buyer representation contract. Option D. It gives the consumer a license to sell property. The correct answer is option C. It is a disclosure only, and representation requires a written listing contract or buyer representation contract. The agency disclosure form informs consumers about relationship options but does not create representation. Representation requires a written contract such as a listing agreement or buyer representation contract. The other choices confuse disclosure with dual agency, purchase contracts, or licensing authority. Question 32. Why might Casey Wilson use a quitclaim deed to clear a possible title issue? Option A. It guarantees the property is free of every lien. Option B. It creates a new mortgage automatically. Option C. It replaces the need for delivery and acceptance. Option D. It transfers whatever interest the grantor may have without making title warranties. The correct answer is option D. It transfers whatever interest the grantor may have without making title warranties. A quitclaim deed can release or transfer any interest the grantor may have, but it does not warrant title quality. It does not guarantee lien-free ownership or create a mortgage. Like other deeds, it still depends on proper execution, delivery, and acceptance. Question 33. In St. Paul, a new applicant asks which combination best describes the salesperson licensing path in Minnesota for Kendall in St. Paul involving a duplex priced at $237,500. Option A. Be at least 18, complete courses 1, 2, and 3, pass the exam, associate with a broker, and receive Commerce Department approval. Option B. Be at least 21, complete only course I, and work independently after passing the exam. Option C. Complete continuing education before any pre-license education and apply directly without a broker. Option D. Pass only the national exam and begin practicing while the application is pending. The correct answer is option A. Be at least 18, complete courses 1, 2, and 3, pass the exam, associate with a broker, and receive Commerce Department approval. Minnesota salesperson licensing requires age eligibility, 3 30-hour pre-license courses, examination success, broker association, and approval by the Commerce Department. The other choices either remove required courses, allow independent practice, or treat a pending application as authority to act. Those alternatives do not satisfy the licensing sequence. Question 34. A listing agreement states the commission amount but does not explain what event earns it. What required item is missing for Emerson in Edina involving a mixed-use property priced at $446,000? Option A. A promise that the buyer will waive inspection. Option B. A clear statement of the events or conditions that entitle the broker to a commission. Option C. A surveyor's certification for every sale. Option D. A court order approving the commission. The correct answer is option B. A clear statement of the events or conditions that entitle the broker to a commission. Minnesota listing agreements must explain the events or conditions that entitle the broker to compensation. Inspection waivers, surveyor certifications, and court orders are not substitutes for commission earning terms. Clear compensation triggers protect both broker and client. Question 35. Which Minnesota tax is generally associated with recording a deed that conveys real property for Rowan and Stillwater involving a condominium unit priced at $250,000? Option A, mortgage registry tax only. Option B, utility franchise fee. Option C, state deed tax. Option D, federal gift tax return fee. The correct answer is option C, state deed tax. Deed tax is generally associated with recording a deed conveying real property. Mortgage registry tax relates to mortgage debt, while utility franchise and federal gift tax issues are outside the ordinary deed recording charge. The transaction document determines which tax applies. Question 36. A borrower signs a promissory note and mortgage to finance a Eden Prairie home. What does the note do for Drew in Eden Prairie involving a farm parcel priced at $216,000? Option A, transfers title to the lender at closing. Option B, sets the zoning classification. Option C, records the deed tax payment. Option D, creates the borrower's personal promise to repay the debt. The correct answer is option D, creates the borrower's personal promise to repay the debt. The promissory note is the borrower's promise to repay according to the loan terms. The mortgage secures that promise with a lien on the property. Zoning, title transfer, and deed tax are separate matters. Question 37. Regarding commission language in a Minnesota listing agreement, which statement best reflects the required consumer notice for Quinn in Woodbury involving a lake cabin priced at $247,000? Option A, compensation is determined between each individual broker and the broker's client. Option B, the state sets one mandatory commission rate for all residential listings. Option C, the MLS sets the minimum commission for every listing. Option D, the buyer must always pay the listing broker directly. The correct answer is option A. Compensation is determined between each individual broker and the broker's client. Minnesota listing agreements must include a notice that compensation is determined between the broker and the broker's client. The state and MLS do not set a universal commission rate for every transaction. Payment arrangements depend on the agreement and cannot be assumed from the listing alone. Question 38. Unless the parties' written agreement says otherwise, when should a Minnesota listing broker deposit earnest money after receiving it and final acceptance has occurred for Rowan and Stillwater involving a farm parcel priced at $193,000? Option A, only after the buyer's loan is fully underwritten. Option B, within 3 business days of receipt or final acceptance, whichever is later. Option C, at any time before the deed is recorded. Option D, within 30 calendar days after the first showing. The correct answer is option B, within 3 business days of receipt or final acceptance, whichever is later. Minnesota trust account rules provide a default deadline of 3 business days after receipt or final acceptance, whichever is later, when the written agreement is silent. Waiting for underwriting, recording, or an arbitrary 30-day period would not meet that default rule. The parties can address timing in their written agreement. Question 39. A deed gives Sawyer possession for life, then ownership passes to Skylar Nolan. What interest does Skylar Nolan hold before Sawyer's death? Option A, leasehold estate. Option B, easement in gross. Option C, remainder interest. Option D, mortgage lien. The correct answer is option C, remainder interest. A remainder interest is a future interest that becomes possessory after a life estate ends. A leasehold is a tenant's possession, an easement in gross is a use right, and a mortgage lien secures debt. The buyer's right follows the life tenant's measuring life. Question 40. During a Stillwater license renewal review, which continuing education schedule best matches Minnesota salesperson requirements for Rowan and Stillwater involving a condominium unit priced at $192,500? Option A, 10 hours every 4 years with no annual deadline. Option B, 30 hours only during the first licensing year. Option C, only the required module with no other continuing education. Option D, 30 hours before the June 30th renewal deadline, with at least 15 hours completed before the previous June 30th. The correct answer is option D, 30 hours before the June 30th renewal deadline, with at least 15 hours completed before the previous June 30th. Minnesota salespersons generally need 30 hours of continuing education before the June 30th renewal deadline, with at least 15 hours due before the previous June 30th. The other options understate the hours, remove the annual structure, or treat the module as the only requirement. Continuing education must be completed in the proper license period. Question 41. If a Bloomington property sells for $421,000 and the buyer obtains an 85% loan, what is the buyer's down payment? Option A, $63,150. Option B, $357,850. Option C, $27,365. Option D, $1,725. The correct answer is option A, $63,150. The down payment is the sale price minus the loan amount. The loan amount is the financed portion, the commission is a brokerage compensation calculation, and the tax proration allocates property taxes. Separating buyer equity from loan proceeds is a core exam math skill. Question 42. If Rowan fails to complete required continuing education by the renewal deadline, what license consequence can occur? Option A. The license automatically converts to a broker license. Option B. The license can become inactive. Option C. The license becomes a deed restriction. Option D. The license renews for free without further action. The correct answer is option B. The license can become inactive. Failure to complete continuing education before the deadline can cause a Minnesota real estate license to become inactive. It does not upgrade the license, affect title to property, or waive renewal obligations. Continuing education is a condition of maintaining active status. Question 43. Before negotiating a purchase involving a licensee's sibling as a principal, what should the licensee do for Reese and Bemidji involving a vacant lot priced at $206,000? Option A. Say nothing because relatives are not licensees. Option B. Disclose only after the commission is paid. Option C. Disclose the relationship in writing before negotiating or consummating the transaction. Option D. Ask the lender to disclose it instead. The correct answer is option C. Disclose the relationship in writing before negotiating or consummating the transaction. Minnesota requires written disclosure when a principal is a licensee's relative or business associate. Waiting until after commission payment is too late, and the duty is not shifted to the lender. The rule protects parties from undisclosed conflicts of interest. Question 44. During negotiations in Brainerd, Morgan Johnson changes the price and closing date in the seller's offer. What is the legal effect of that response? Option A. It is an acceptance because some terms stayed the same. Option B. It creates a lease instead of a purchase contract. Option C. It keeps the original offer open forever. Option D. It is a counteroffer that rejects the original offer and proposes new terms. The correct answer is option D. It is a counteroffer that rejects the original offer and proposes new terms. Changing material terms creates a counteroffer rather than an acceptance. The original offer is rejected unless the offeror renews or accepts the new terms. Keeping some terms unchanged does not preserve the original offer forever or convert the transaction into a lease. Question 45. Under Minnesota licensing rules, what happens when a salesperson's association with an actively licensed broker ends for Kendall in St. Paul involving a rental house priced at $433,000? Option A. The salesperson's license becomes inactive until proper association is restored. Option B. The salesperson may continue independently for 90 days. Option C. The salesperson automatically becomes a limited broker. Option D. The salesperson may transfer clients without broker supervision. The correct answer is option A. The salesperson's license becomes inactive until proper association is restored. A salesperson license depends on active association with a licensed broker. Ending that association makes the license inactive, so independent practice is not allowed. Automatic broker status and unsupervised client transfers are not part of the salesperson licensing structure. Question 46. A property owner dies with no will and no heirs. What government power may transfer the property to the state for Drew in Eden Prairie involving a condominium unit priced at $469,000? Option A, eminent domain. Option B, this cheat. Option C, literal rights. Option D, subordination. The correct answer is option B, is cheat. Is cheat transfers property to the state when an owner dies without a will and without heirs. Eminent domain involves compensated taking, literal rights involve water, and subordination changes lien priority. The absence of heirs is the clue. Question 47. A property manager collects rent for an owner in Edina. How should those funds generally be treated before proper disbursement for Emerson in Edina involving a lake cabin priced at $410,000? Option A, as the manager's personal operating funds. Option B, as sales tax collected for the state. Option C, as trust funds handled according to the broker's trust account obligations. Option D, as title insurance premiums. The correct answer is option C, as trust funds handled according to the broker's trust account obligations. Rent collected for an owner is money held for another and must be handled under trust accounting duties. It is not the manager's personal money, a sales tax fund, or a title insurance premium. Property management requires careful separation of client funds. Question 48. Which fiduciary duty requires a broker to keep client money and property properly accounted for Finley in Minneapolis involving a lake cabin priced at $398,500? Option A, assemblage. Option B, accretion. Option C, devolution. Option D, accounting. The correct answer is option D, accounting. Accounting requires a broker to account for money and property received on behalf of a client. Assemblage, accretion, and avulsion are property or land concepts, not fiduciary duties. The key clue is handling client property and funds. Question 49. A zoning ordinance limits building height in Woodbury. What government power is most directly involved? Option A, police power. Option B, eminent domain. Option C, this cheat. Option D, taxation only. The correct answer is option A, police power. Police power allows government to regulate property use for health, safety, morals, and general welfare. Eminent domain is taking for public use, cheat handles ownerless property, and taxation raises revenue. Zoning is a classic police power regulation. Question 50. A broker tells competing firms to keep commissions at the same percentage in Maple Grove. What legal risk is most obvious? Option A, accretion. Option B, price fixing under antitrust law. Option C, constructive eviction. Option D, of functional obsolescence. The correct answer is option B, price fixing under antitrust law. Competitors agreeing on commission rates can be price fixing, an antitrust violation. Accretion, constructive eviction, and functional obsolescence involve land change, landlord-tenant issues, and valuation. Commissions must be independently negotiated, not fixed by competitors. Question 51. A zoning board permits a property use that otherwise violates strict zoning because of unique hardship. What relief is typically granted for Casey and Mankato involving a mixed-use property priced at $344,500? Option A, certificate of title. Option B, quitclaim covenant. Option C, variance. Option D, mortgage assumption. The correct answer is option C, variance. A variance provides relief from strict zoning requirements when legal standards are met, often involving unique hardship. Certificates of title, quitclaim deeds, and mortgage assumptions do not authorize zoning deviations. Land use approval is the issue. Question 52. Which appraisal approach is usually most persuasive for a typical owner-occupied home in a subdivision with many recent comparable sales for Taylor and Rochester involving a newly built townhouse priced at $448,000? Option A, cost approach only. Option B, income approach only. Option C, front foot method only. Option D, sales comparison approach. The correct answer is option D, sales comparison approach. The sales comparison approach is usually strongest when similar properties have sold recently in the same market. The cost approach can be useful for new or special purpose improvements, and the income approach is more relevant to income-producing property. Front foot analysis is a land valuation tool, not the main method for a typical home. Question 53. A broker learns that a foundation defect could significantly affect Morgan Johnson's use of a small retail building in Brainerd. What should the broker do? Option A, disclose the material fact to the prospective purchaser. Option B, stay silent because the defect might reduce the seller's price. Option C, disclose only after closing if the buyer complains. Option D, treat the defect as confidential even if it affects use and enjoyment. The correct answer is option A, disclose the material fact to the prospective purchaser. Known material facts that could adversely and significantly affect an ordinary buyer's use or enjoyment must be disclosed. Protecting a sale price does not excuse non-disclosure, and waiting until after closing defeats the purpose of the rule. Confidentiality does not cover facts that law requires to be disclosed. Question 54. A residential buyer has not signed a representation contract. How should the licensee describe the buyer's status after agency disclosure for Morgan in St. Cloud involving a rental house priced at $252,500? Option A. The buyer is automatically a client forever. Option B. The buyer is a customer unless and until a written representation contract is signed. Option C. The buyer becomes the broker's employee. Option D. The buyer receives ownership rights in the brokerage. The correct answer is option B. The buyer is a customer unless and until a written representation contract is signed. Minnesota agency disclosure explains that a consumer is not represented until a written representation contract is signed. Customer status is different from client representation. Employment and ownership rights are not created by receiving agency disclosure. Question 55. Before Riley schedules the salesperson examination after studying in Duluth, which pre-license course must already be completed? Option A, Course 2 only. Option B, Course 3 only. Option C, Course I. Option D, the annual continuing education module. The correct answer is option C, Course I. Course I must be successfully completed before a candidate registers for the salesperson examination. Course 2 and Course 3 are required before license application, while the annual module is a continuing education requirement for licensees. Confusing pre-license and continuing education rules leads to the wrong result. Question 56. A salesperson discovers an error in an advertisement after publication. What is the most professional next step for Cameron in Brainerd involving a small retail building priced at $320,000? Option A, ignore it because errors in ads never matter. Option B, blame the buyer publicly. Option C, delete all transaction records. Option D, promptly correct the advertisement and notify the broker according to office procedures. The correct answer is option D, promptly correct the advertisement and notify the broker according to office procedures. Advertising must be accurate and compliant, so prompt correction and broker notification are appropriate. Ignoring errors, blaming clients, or deleting records creates greater compliance risk. Professional practice requires correction and documentation. Question 57. If a broker provides the predatory offender registry notice in a timely manner, what is generally true about offender registry information for Riley in Bloomington involving a farm parcel priced at $203,500? Option A. The broker has no duty to disclose specific registry information beyond the required notice. Option B. The broker must personally investigate every nearby resident. Option C. The broker must guarantee no offenders live in the city. Option D. The broker must cancel the purchase agreement automatically. The correct answer is option A. The broker has no duty to disclose specific registry information beyond the required notice. Minnesota disclosure law limits a licensee's duty regarding registry information when the required notice is provided. The broker does not guarantee neighborhood conditions or act as law enforcement. Automatic contract cancellation is not the disclosure rule. Question 58. Before advertising Kendall Chen's fourplex to the general public, what must a Minnesota licensee obtain? Option A. An oral promise that the owner may list later. Option B. A signed listing agreement or other signed written authorization from the owner or authorized person. Option C. A buyer's pre-approval letter. Option D. A tax parcel map from the county. The correct answer is option B. A signed listing agreement or other signed written authorization from the owner or authorized person. A licensee must have a signed listing agreement or other signed written authorization before advertising real property for sale or lease to the general public. Oral permission is not enough for this requirement. Buyer pre-approval and tax maps may be useful, but they do not authorize public advertising. Question 59. A Minnesota salesperson renewal fee includes a contribution to which fund for Morgan and St. Cloud involving a rental house priced at $238,000? Option A. Federal Flood Insurance Reserve. Option B. County Recording Technology Fund only. Option C. Real Estate Education, Research and Recovery Fund. Option D. Private MLS Scholarship Account. The correct answer is option C. Real Estate Education, Research and Recovery Fund. Minnesota salesperson license fees include an amount for the Real Estate Education, Research and Recovery Fund. Flood insurance reserves, county recording funds, and private MLS accounts are unrelated. The fund is part of the state licensing fee structure. Question 60. A St. Cloud listing agreement omits the real property description. What required element is missing? Option A. The buyer's credit score. Option B. The lender's underwriting model. Option C. The appraiser's license number. Option D. A description of the real property involved. The correct answer is option D. A description of the real property involved. Minnesota listing agreements must describe the real property involved. A buyer's credit score, underwriting model, or appraiser license number is not a required listing agreement element. The contract must identify the property being offered. Question 61. A buyer receives a qualified third-party inspection report, but the licensee knows a fact that contradicts it. What must the licensee do for Parker in Moorhead involving a duplex priced at $372,500? Option A. Disclose known facts that contradict the report. Option B. Stay silent because the report always controls. Option C. Destroy the report and order a new one. Option D. Tell only the inspector after closing. The correct answer is option A. Disclose known facts that contradict the report. A licensee may rely on a qualified third-party report unless the licensee knows facts that contradict it. Known contradictions must be disclosed to the parties. Silence, destruction of the report, or delayed notice would undermine the disclosure duty. Question 62. Which Minnesota tax is generally associated with recording a mortgage that secures debt on real property for Finley in Minneapolis involving a lake cabin priced at $306,000? Option A. Personal income withholding tax. Option B. Mortgage registry tax. Option C. Sales tax on furniture. Option D. Special assessment appeal fee. The correct answer is option B. Mortgage registry tax. Mortgage registry tax is tied to the recording of a mortgage securing debt. Personal income withholding, furniture sales tax, and assessment appeals are different issues. The exam often distinguishes mortgage registry tax from deed tax. Question 63. A utility company has the right to run power lines across Eden Prairie parcel. Which property right is usually involved for Drew in Eden Prairie involving a vacant lot priced at $375,000? Option A. Estate for years. Option B. Divulsion. Option C. Easement in gross. Option D. A remainder interest. The correct answer is option C, easement in gross. A utility easement often benefits a company rather than a neighboring parcel, making it an easement in gross. An estate for years is a leasehold, a volition is sudden land change, and a remainder follows a life estate. The utilities right is a non-possessory use right. Question 64. A licensee in Bemidji drafts a complex legal clause for Finley Anderson instead of recommending legal counsel. What risk is created? Option A, constructive eviction. Option B, of functional obsolescence. Option C, inverse condemnation. Option D, unauthorized practice of law. The correct answer is option D, unauthorized practice of law. Licensees may fill in approved forms and explain business terms, but drafting legal clauses can cross into unauthorized practice of law. Constructive eviction, functional obsolescence, and inverse condemnation describe different legal or valuation issues. Complex legal drafting should be handled by an attorney. Question 65. A lender draws a line around a Crow Wing neighborhood and refuses otherwise qualified mortgage applicants there. What fair housing and lending term best fits for Parker in Moorhead involving a rental house priced at $364,500? Option A, redlining. Option B, plottage. Option C, accretion. Option D, estoppel. The correct answer is option A, redlining. Redlining is denying or limiting credit in an area for discriminatory reasons rather than evaluating individual qualifications. Plottage relates to value from assemblage, accretion is natural land buildup, and estoppel prevents inconsistent claims. Area-based discriminatory lending violates fair lending principles. Question 66. At Lakeside Realty, a salesperson asks which online system the Commerce Department uses for many licensing services such as applications, renewals, and transfers for Taylor in Rochester involving a small retail building priced at $418,000. Option A, MLS Grid. Option B, Pulse. Option C, Torrens Online. Option D, HUD Exchange. The correct answer is option B, Pulse. Pulse is the electronic licensing system used for many Minnesota Commerce Department licensing services. MLS systems, Torrens records, and HUD resources serve different purposes. Knowing the licensing portal helps distinguish administrative filing from transaction records and federal housing resources. Question 67. When Cameron, a licensee, intends to buy a client's property in Winona, what disclosure is required before negotiation or consummation? Option A. The licensee may stay silent if paying full market value. Option B. The disclosure is needed only after the deed is recorded. Option C. The licensee must affirmatively disclose the license status and the capacity in which the licensee is acting. Option D. Only the buyer's lender must be told about the license. The correct answer is option C. The licensee must affirmatively disclose the license status and the capacity in which the licensee is acting. A Minnesota licensee who acquires or intends to acquire an interest in real property must disclose the license status and capacity before negotiation or consummation. Paying market value does not remove the conflict risk, and post-recording disclosure would be too late. Lender-only notice does not satisfy disclosure to the property owner. Question 68. A tenant with a disability asks for an assigned accessible parking space near the entrance. What fair housing concept is most directly involved for Hayden in Maple Grove involving a duplex priced at $267,500? Option A, adverse possession. Option B, yield spread premium. Option C, defeasance clause. Option D, reasonable accommodation. The correct answer is option D, reasonable accommodation. A reasonable accommodation is a change in rules, policies, or services that may be needed for a person with a disability to use and enjoy housing. Adverse possession concerns ownership claims, yield spread premiums concern loan compensation, and defeasance clauses concern loan satisfaction. The requested parking change involves access to housing. Question 69. Why would an appraiser rely heavily on the cost approach for a newly built fourplex in St. Paul for Kendall in St. Paul involving a fourplex priced at $193,500? Option A. Replacement cost and depreciation can be estimated more reliably for new improvements. Option B. It ignores land value completely. Option C. It is the only legal method for all residential property. Option D. It values the property only by monthly rent. The correct answer is option A. Replacement cost and depreciation can be estimated more reliably for new improvements. The cost approach is useful for new construction because replacement cost and accrued depreciation can be estimated with less uncertainty. It still includes land value and is not the only legal method for every property. Monthly rent belongs to income analysis rather than cost analysis. Question 70. A tenant remains in possession after a lease expires without the landlord's consent. What is the tenant's status for Skylar in Northfield involving a fourplex priced at $445,000? Option A. Remainderman. Option B. Tenant at sufferance. Option C. Joint tenant. Option D. Dominant tenant. The correct answer is option B. Tenant at sufferance. A tenant at sufferance is a holdover who originally had lawful possession but stays without consent after the right ends. A remainderman holds a future interest, a joint tenant is a co-owner, and dominant tenant is not the standard term. The holdover fact controls. Question 71. In appraisal, what does highest and best use require for Casey and Mankato involving a mixed-use property priced at $243,500? Option A. The use that produces the highest commission. Option B. The use preferred by the current tenant only. Option C. A use that is legally permissible, physically possible, financially feasible, and maximally productive. Option D. The use with the lowest property tax bill. The correct answer is option C. A use that is legally permissible, physically possible, financially feasible, and maximally productive. Highest and best use considers legal, physical, financial, and productivity tests. Commission, tenant preference, and tax savings alone do not determine highest and best use. The concept focuses on the most supportable use of the property as real estate. Question 72. A contract substitutes a new party and releases the original party from liability. Which term best describes that change for Sawyer and Winona involving a newly built townhouse priced at $379,500? Option A. Assignment only. Option B. Accretion. Option C. Hypothecation. Option D. Novation. The correct answer is option D. Novation. Novation substitutes a new obligation or party and releases the original party when all required parties agree. Assignment transfers rights but does not necessarily release the assignor. Accretion and hypothecation involve land buildup and pledging property as security. Question 73. While interviewing with two firms in Mankato, Quinn asks how many Minnesota brokers may supervise the salesperson during the same period. Option A. 1 actively licensed broker. Option B. 2 brokers if both brokers consent. Option C. Any number of brokers if the salesperson discloses the arrangement. Option D. 1 broker for residential sales and a separate broker for leases. The correct answer is option A. 1 actively licensed broker. A salesperson in Minnesota is licensed to act on behalf of 1 broker during the same period. Consent or disclosure does not create authority to work under multiple brokers. Splitting residential and leasing work between brokers would still violate the Single Broker Association rule. Question 74. 2 brokerages agree that one will work only north of Eden Prairie and the other only south. What antitrust violation may this suggest? Option A. Redemption. Option B. A market allocation. Option C. Assemblage. Option D. Is subrogation. The correct answer is option B. Market allocation. Market allocation occurs when competitors divide customers or territories instead of competing. Redemption, assemblage, and subrogation are unrelated real estate concepts. Geographic division by competing brokerages creates serious antitrust risk. Question 75. A buyer deposits earnest money with a broker in the form of a negotiable note rather than cash. What extra care is needed for Skylar in Northfield involving a fourplex priced at $437,500? Option A. The broker may throw it away because it is not cash. Option B. It can be placed in the broker's personal safe without records. Option C. The non-depositable item must be handled through authorized escrow with written authority and proper records. Option D. It automatically becomes commission income. The correct answer is option C. The non-depositable item must be handled through authorized escrow with written authority and proper records. Non-depositable items received as earnest money require careful escrow handling, written authority when the broker holds them, and proper records. They are not discarded, hidden as personal property, or treated as commission income. The rule protects all parties' interests in non-cash deposits. Question 76. If a seller rejects Kendall Kahn's offer and the listing broker holds the earnest money, when should the rejected offer's earnest money be returned? Option A. Only after the seller signs a different purchase agreement. Option B. At the end of the listing period. Option C. After the broker deducts marketing expenses. Option D. No later than the next business day after rejection. The correct answer is option D. No later than the next business day after rejection. When an offer is rejected, Minnesota trust account rules require earnest money to be returned to the potential buyer no later than the next business day after rejection. The broker cannot hold it until another sale, listing expiration, or reimbursement of marketing costs. Rejected offers do not create a right to keep the buyer's funds. Question 77. Gradual soil buildup along a stream increases a parcel's size. What term best fits for Riley and Bloomington involving a vacant lot priced at $315,000? Option A. Accretion. Option B. Divulsion. Option C. Condemnation. Option D. Defeasance. The correct answer is option A. Accretion. Accretion is gradual addition of land through natural forces. Avulsion is sudden change. Condemnation is taking by eminent domain, and defeasance concerns loan satisfaction. Gradual buildup is the key clue. Question 78. Under the Minnesota Human Rights Act, which protected basis expands beyond the traditional federal fair housing list for Harper and Blaine involving a small retail building priced at $416,000? Option A. Preference for a short commute. Option B. Status with regard to public assistance. Option C. Owning two vehicles. Option D. Having a fixed-rate mortgage. The correct answer is option B. Status with regard to public assistance. Minnesota housing and real property discrimination law includes status with regard to public assistance among protected bases. Commute preference, vehicle ownership, and mortgage type are not protected classes. State law can add protections beyond the federal baseline. Question 79. A parcel borders a lake near Mankato. Rights associated with use of the lake shore are commonly called what? Option A. Riparian rights only. Option B. Fixture rights. Option C. Littoral rights. Option D. Novation rights. The correct answer is option C. Littoral rights. Littoral rights generally relate to property bordering lakes, seas, or oceans. Riparian rights involve rivers and streams. Fixtures concern attached property, and novation is contract substitution. The lakefront fact drives the answer. Question 80. At closing, why are prepaid property taxes or rents commonly prorated between buyer and seller for Schuyler in Northfield involving a rental house priced at $310,500? Option A. To change the sales price after acceptance. Option B. To avoid recording the deed. Option C. To eliminate the need for title insurance. Option D. To allocate income or expenses to the party who owned the property during the relevant time period. The correct answer is option D. To allocate income or expenses to the party who owned the property during the relevant time period. Priorations allocate recurring income and expenses based on the period each party is entitled to or responsible for them. They do not rewrite the price, avoid recording, or replace title insurance. Closing statements use debits and credits to make this allocation. Question 81. A rumor says a Bloomington home was once the site of a natural death and possible paranormal activity. Under Minnesota disclosure rules, How is that fact treated for Riley in Bloomington involving a vacant lot priced at $439,000? Option A. It is not treated as a material fact that must be disclosed merely for that reason. Option B. It must always be disclosed in the listing contract. Option C. It makes the property unmarketable until court approval. Option D. It requires the buyer to receive a separate environmental report. The correct answer is option A. It is not treated as a material fact that must be disclosed merely for that reason. Minnesota law states that certain stigmatizing facts, such as suicide, natural death, or perceived paranormal activity, are not material facts requiring disclosure merely because they occurred. That does not change the duty to disclose physical defects or other material facts. Listing contracts, court approval, and environmental reports address different issues. Question 82. A listing contract says it may be cancelled only under certain stated conditions. Why does that matter for Drew in Eden Prairie involving a vacant lot priced at $325,000? Option A. Cancellation terms are never allowed in listing agreements. Option B. Minnesota listing agreements must explain whether cancellation is allowed and the terms for cancellation. Option C. Only the buyer may cancel a seller's listing. Option D. The broker can cancel only by recording a deed. The correct answer is option B. Minnesota listing agreements must explain whether cancellation is allowed and the terms for cancellation. Minnesota listing agreements must include a clear statement explaining if the agreement may be cancelled and the cancellation terms. The issue is contract clarity, not deed recording or buyer control. Stated cancellation terms help prevent disputes. Question 83. In a gross lease for a more head office, which cost structure is most typical? Option A. The tenant pays all property taxes, insurance, and maintenance separately. Option B. The tenant receives title at the end of the lease. Option C. The landlord pays most property operating expenses from the rent received. Option D. The rent is based only on retail sales volume. The correct answer is option C. The landlord pays most property operating expenses from the rent received. In a gross lease, the landlord typically pays most operating expenses and receives rent as a gross amount. Net leases shift more expenses to the tenant, and percentage leases tie rent partly to sales. A lease does not transfer title merely because it is gross. Question 84. In a lien theory mortgage state such as Minnesota, what does the mortgage usually give the lender for Morgan in St. Cloud involving a rental house priced at $460,000? Option A. Immediate ownership and possession of the property. Option B. A life estate measured by the borrower's life. Option C. A leasehold estate for the loan term. Option D. A lien securing repayment while the borrower retains title. The correct answer is option D. A lien securing repayment while the borrower retains title. In lien theory, the mortgage gives the lender a security lien rather than immediate title and possession. The borrower retains legal title unless foreclosure changes ownership. Life estates and leaseholds are different interests, not the ordinary mortgage relationship. Question 85. A licensee directs families with children only toward one area of Brainerd. What fair housing problem does that conduct create? Option A. Steering. Option B. Amortization. Option C. Subordination. Option D. Novation. The correct answer is option A. Steering. Steering occurs when a real estate professional guides prospects toward or away from areas based on a protected characteristic. Amortization is loan repayment, subordination is lien priority adjustment, and novation is contract substitution. The conduct described limits housing choice and raises fair housing risk. Question 86. Which fiduciary duty requires a broker to follow a client's lawful directions for Harper & Blaine involving a small retail building priced at $332,000? Option A. Is cheat. Option B. Obedience. Option C. Novation. Option D. Subordination. The correct answer is option B. Obedience. Obedience requires following lawful client instructions. It does not require obeying illegal instructions or ignoring disclosure duties. Is cheat, novation, and subordination are unrelated legal concepts. Question 87. A pooled interest-bearing trust account earns interest on client funds, unless otherwise agreed, where is the interest generally paid under Minnesota rules for Sawyer and Winona involving a small retail building priced at $455,500? Option A. To the salesperson as a bonus. Option B. To the listing client automatically. Option C. To the Minnesota Housing Finance Agency for the Housing Trust Fund account. Option D. To the county assessor's operating budget. The correct answer is option C. To the Minnesota Housing Finance Agency for the Housing Trust Fund account. Minnesota rules direct interest from pooled trust accounts, less reasonable costs, to the Minnesota Housing Finance Agency for the Housing Trust Fund account unless the parties specify otherwise. The salesperson, listing client, and county assessor are not the default recipients. Trust account interest is regulated separately from commission. Question 88. A licensee in St. Paul wants to know which required continuing education topics must be included in the renewal cycle along with the general module. Option A. Only appraisal theory and mortgage underwriting. Option B. Only property insurance and income tax preparation. Option C. Only construction codes and zoning administration. Option D. Agency law and fair housing. The correct answer is option D. Agency law and fair housing. Minnesota renewal requirements include agency representation and disclosure training and fair housing training as part of the required education mix. Appraisal, insurance, tax, construction, and zoning topics may be useful, but they do not replace those mandated topics. The rule is designed to keep licensees current on representation and anti-discrimination duties. Question 89. A Maple Grove buyer's loan has small monthly payments but one large final payment. What is that final payment called for Hayden in Maple Grove involving a fourplex priced at $210,000? Option A. Balloon payment. Option B. Proration credit. Option C. Replacement reserve. Option D. Equity dividend. The correct answer is option A. Balloon payment. A balloon payment is a large unpaid balance due at the end of a loan term. A proration credit divides expenses at closing, a replacement reserve funds future repairs, and an equity dividend is an investment return measure. The structure described is a financing feature. Question 90. Under federal fair housing law, which group is a protected class in the sale or rental of housing for Reese and Bemidji involving a vacant lot priced at $208,500? Option A. Credit score above 700. Option B. Familial status. Option C. Preference for lakefront homes. Option D. Employment in real estate sales. The correct answer is option B. Familial status. Familial status is a protected class under federal fair housing law. Credit score, housing preferences, and occupation in real estate are not protected classes by themselves. Housing decisions must avoid discrimination based on protected characteristics. Question 91. A licensee exaggerates by saying a backyard view is the best sunset in Minnesota. How is that usually classified for Parker and Moorhead involving a fourplex priced at $280,000? Option A. A guaranteed appraisal. Option B. A material title defect. Option C. Puffing if it is clearly opinion rather than a factual claim. Option D. A deed restriction. The correct answer is option C. Puffing if it is clearly opinion rather than a factual claim. Puffing is an opinion or sales statement that a reasonable person would not treat as a factual guarantee. It differs from misrepresenting a known defect or title issue. The sunset statement is subjective unless tied to a specific false fact. Question 92. A Granite Realty branch office wants licensees to access current Minnesota statutes and rules electronically. Is electronic access acceptable for Skylar in Northfield involving a fourplex priced at $218,500? Option A. No, only a paper binder signed by every buyer is allowed. Option B. Yes, but only if clients pay a records fee. Option C. No, statutes are never required in real estate offices. Option D. Yes, access to required statutes and rules may be made available electronically. The correct answer is option D. Yes, access to required statutes and rules may be made available electronically. Minnesota standards allow access to required statutes and rules through an electronic agent. A paper-only rule, client fee requirement, or no access approach misstates the standard. The point is that licensees must have current legal resources available. Question 93. Which ownership estate gives Finley Peterson the greatest bundle of rights with no stated end date or condition? Option A, fee simple absolute. Option B, estate at sufferance. Option C, life estate. Option D, license. The correct answer is option A, fee simple absolute. Fee simple absolute is the broadest ownership estate and can continue indefinitely. A life estate ends with a measuring life, an estate at sufferance arises from holdover possession, and a license is permission rather than an estate. The key phrase is ownership without a stated end date or condition. Question 94. Which lease gives a tenant possession for a fixed term that ends automatically on the stated expiration date for Finley in Minneapolis involving a lake cabin priced at $388,000? Option A, tenancy at sufferance. Option B, the state for years. Option C, fee simple defeasible. Option D, easement appurtenant. The correct answer is option B, estate for years. An estate for years is a leasehold for a definite period and ends at the stated expiration. Tenancy at sufferance is holdover possession after lawful possession ends. Fee simple defeasible and easement appurtenant are not ordinary fixed-term leasehold estates. Question 95. During a first substantive contact with a residential consumer in Stillwater, what disclosure should the licensee provide for Rowan and Stillwater involving a condominium unit priced at $391,500? Option A, a final closing disclosure showing loan terms. Option B, a county tax statement for the current year. Option C, an agency disclosure form explaining available agency and facilitator relationships. Option D, a deed prepared for recording. The correct answer is option C, an agency disclosure form explaining available agency and facilitator relationships. Minnesota requires an agency disclosure form at the first substantive contact in residential transactions covered by the statute. The form explains representation choices and facilitator status before the consumer decides whether to enter a representation contract. Closing disclosures, tax statements, and deeds serve different functions later in the transaction. Question 96. A listing agreement for a Bloomington seller is missing a definite end date. Why is that a licensing problem for Riley in Bloomington involving a condominium unit priced at $227,500? Option A, listing agreements are valid only if they renew forever. Option B, expiration dates are allowed only in commercial leases. Option C, the county recorder assigns the expiration date after closing. Option D, Minnesota listing agreements must include a definite expiration date. The correct answer is option D. Minnesota listing agreements must include a definite expiration date. Minnesota listing agreements must be written and include a definite expiration date. Automatic indefinite listings create consumer protection concerns and do not meet the required content rules. County recorders do not supply listing agreement expiration dates. Question 97. A city takes private land for a public road after paying just compensation. What power is being exercised for Avery in Eagan involving a townhome priced at $461,000? Option A, eminent domain. Option B, this cheat. Option C, adverse possession. Option D, police power only. The correct answer is option A, eminent domain. Eminent domain is the government's power to take private property for public use with just compensation. Escheat transfers property to the state when no heirs exist, and adverse possession is private acquisition through possession. Police power regulates use but does not by itself describe a compensated taking. Question 98. A broker closes an existing trust account without notice. Why is that a problem under Minnesota trust account rules for Kendall in St. Paul involving a fourplex priced at $395,000? Option A, trust accounts may never be changed under any circumstances. Option B, a broker or closing agent must give written notice to the commissioner before closing an existing trust account. Option C, Only buyers can close brokerage trust accounts. Option D. Trust accounts are optional for earnest money. The correct answer is option B. A broker or closing agent must give written notice to the commissioner before closing an existing trust account. Minnesota rules require notice of trust account status changes and written notice before closing an existing account. This does not mean accounts can never change, but they must be properly reported. Buyers do not control brokerage trust accounts, and trust accounts are not optional when trust funds must be held. Question 99. A buyer asks whether a nursing home in the neighborhood must be disclosed as a material fact. How does Minnesota treat the issue for Parker and Moorhead involving a fourplex priced at $383,500? Option A. It is always a material defect in the property. Option B. It requires a separate appraisal license. Option C. The location of a nursing home nearby is not a material fact that must be disclosed merely for that reason. Option D. It makes the deed void. The correct answer is option C. The location of a nursing home nearby is not a material fact that must be disclosed merely for that reason. Minnesota law excludes certain neighborhood-related facilities, including nursing homes, from material fact treatment merely because they are nearby. This does not remove duties to disclose physical defects or known material facts. Appraisal licensing and deed validity are unrelated. Question 100. A lot has 285 front feet worth $270 per front foot. What is the indicated front foot value? Option A, $1,642. Option B, $11,475. Option C, $506,667. Option D, $76,950. The correct answer is option D, $76,950. Front foot valuation multiplies frontage by the price per front foot. Tax proration, commission, and income capitalization rely on other formulas. The question asks only for the land value indicated by frontage.